Hello everyone, I'm Adrian Barnett and I'm a senior lecturer in law at Brunel University, London. Today I'm going to talk about parental alienation in England and Wales. This is a controversial topic which has given rise to heated debate, as we saw in the House of Lords debates on the Domestic Abuse Bill. I'm not going to focus on the theory or concept of parental alienation itself, but rather on the way in which it plays out in family court proceedings. The evidence and information on this is somewhat scanty, and apart from the Ministry of Justice Harm Panel report, somewhat out of date. In addition to my small-scale study of reported and published judgments, this presentation will include the outcomes from a workshop held in January 2020 at Brunel, which included 20 lawyers, academics, child welfare professionals, and representatives of stakeholder groups. And I should mention that the study by Doughty et al. With Kafkas Cymru excluded cases involving domestic abuse allegations. Birchall and Chowdhury didn't set out to investigate parental alienation, but many of the women they surveyed and interviewed raised it unprompted. And I'll refer to a few international studies where they illustrate aspects of parental alienation in England and Wales. Parental alienation is a huge topic, but these are the main themes that emerged not only from my study, but from the other sources. I don't have time during this presentation to discuss how parental alienation emerged into family law in England and Wales, in its original manifestation of parental alienation syndrome, but I'm happy to do so at the conference. There is no empirical evidence available on the prevalence of allegations or findings of parental alienation in the family courts in England and Wales. My review of the case law found very few reported or published judgments, and Doughty and others found even fewer. 40 cases contained in 54 judgments was the total number I found up to the end of March 2019, using the search terms parental alienation syndrome, parental alienation, and alienation. Of course, the reported and published cases can't provide a representative sample of all parental alienation cases dealt with by the lower courts. Most private law children cases are conducted by district judges or magistrates, whose decisions are rarely, if ever, reported or published on Bailey. However, the workshop at Brunel, the Harm Panel report, and anecdotal evidence indicate strongly that in recent years, claims of parental alienation have become prolific. A lawyer at the workshop said that it was raised in nearly every private law case in which she was instructed. There is no official or commonly accepted definition of parental alienation, and there are a wide range of views on what parental alienation is and how to identify it. There's also a lack of consistency in how the courts interpret and define parental alienation, which, as Matthew Richardson, a barrister, pointed out in this quote here, can lead to a great deal of operating at cross purposes. Suzanne Zakur's 2018 Quebec study found that courts adopt either a child-focused approach, focusing on whether a child shows signs of alienation, or a parent-focused approach, focusing on alienating behaviors. She found that a parent-focused approach predominated, something I observed in the England and Wales case law, and amplified the prevalence of parental alienation in custody disputes, and concluded that parental alienation, quotes, can mean whatever the judge wants it to mean. Liz Sheehy and Simon Lapierre point out that parental alienation is used so broadly as to designate any situation where a parent is perceived as engaging in strategies to exclude the other parent, regardless of whether the child actually rejects the other parent. Again, something I observed in the English case law. A strong theme that emerged from various sources related to parental alienation and domestic abuse. My study found high levels of domestic abuse in cases in which parental alienation is raised. And this was also reported at the workshop and has been found in studies undertaken in the US, Canada, Australia, New Zealand, Spain, and Italy. I also found a minimal application of Practice Direction 12J, which was also reported by participants in the workshop, which leads to a focus on parental alienation rather than on domestic abuse. The Ministry of Justice Harm Panel received reports that perpetrators sometimes raised counter-allegations of parental alienation, which were taken seriously by courts and professionals, even where there was little or no supporting evidence. And a number of sources reported that victim survivors of domestic abuse can be discouraged from raising domestic abuse for fear of being accused of parental alienation. And similar findings to these have been made in US, Canadian, and Australian research. Joan Meyer undertook the largest empirical study on parental alienation. It's a national US study which identified and analysed 4,338 judgments. And she found that when mothers claimed abuse and fathers cross-claimed parental alienation, courts were more than twice as likely to disbelieve the mother's claims than if fathers made no parental alienation claim. Similarly, Liz Sheehy and Susan Boyd, in their analysis of Canadian reported judgments, found that judges were more likely to focus on alienating behaviours than on domestic abuse, and also that domestic abuse was rarely condemned or related to children's best interests in the way that alienation was. A strong theme that emerged from these sources was the way in which parental alienation could dominate cases at the expense of an analysis of the best interests of the child. It can reduce the complex lives, emotions, and circumstances of children and parents before the family courts to the single issue of alienation, which was a strong theme at the workshop. Mayer and Dixon in their US pilot study, and Linda Nielsen in her large-scale Canadian study of reported judgments, found that parental alienation being used in cases can distort analysis of the best interests of the child by deflecting attention from a proper scrutiny of parent-child relationships and parenting practices, and can lead to plausible explanations for children's resistance to contact being ignored or overlooked. Another strong theme was the way in which parental alienation can silence children's voices. In my study, while some judges took children's wishes and feelings very seriously, others ignored children's expressed wishes and feelings, putting them down to coaching or brainwashing, and in this way filtering them through discourses of parental alienation. Specialist participants at the workshop reported that children's voices are not heard and their experiences are not understood, which increases children's powerlessness and can impede work in helping children to heal. Specialist participants in the workshop and harm panel respondents advised how harmful it is for children to be encouraged to disregard their own fear and distress, or be told that their experiences aren't real or that they'll get used to it. And this quote from a young person who participated in a focus group in the MOJ inquiry shows how children may be left isolated and suffering ongoing abuse through contact because of their concern that their mother's perceived failure to promote contact could be used against them in court to demonstrate alienation. As far as the experts are concerned, the case law I reviewed indicated an increasing number of parental alienation experts being instructed in cases from 2017 who were considered credible and reliable by the courts. but concerns were expressed at the workshop that once a parental alienation expert is instructed, they invariably diagnose parental alienation. And my study found the huge power that the experts exercise in family court proceedings. Although the case law did reveal some skepticism of the parental alienation industry, and some judges were quite critical of parental alienation therapists. More recently, concerns have been raised about the credentials of some experts and whether these are sufficiently scrutinized by courts. Finally, going on to transfers of residence, there were very few transfers of residence in the case law that I reviewed, only 5 during the 20-year period. Of course, there were more changes of residence in the case law generally, but this was the total number of such cases in which parental alienation was invoked. However, the workshop, the research by Birchall of Chowdhury, and the harm panel report all reported a much higher incidence of transfers of residence than was found in the case analysis. I found that the outcomes do not necessarily reveal the benefits for children of forced transfers. In 2 cases I reviewed, children were ultimately returned to their mothers, clinically depressed, traumatized, and suicidal. And in 2 cases, it appeared that following the transfer, the fathers were impeding the mother's contact. Joan Mayer's research found that in cases where mothers claimed abuse, fathers' parental alienation claims roughly doubled mothers' rates of losing custody. And mothers' rates of losing custody increased to 73% when parental alienation was credited by the courts. At the conference, I can let you know a little bit more about the research by Joy Silberg and Stephanie Dallum of turnaround cases, and I'll tell you what this photograph is about. So thank you very much for listening, and I look forward to seeing you at the conference.